All right, everyone, we're going to go ahead and get started. So first, I'd like to start by introducing myself. My name is Diego Alvarez. I am the managing editor of the Harvard Law Record. So historically speaking, the Record has tried to push neutral ideas out into the world. We very highly recommend people send in their opinions and try to get the environment of what Harvard Law School is like at any point in time. There will be a couple of copies of our most recent issue that we released for orientation. So if you guys would like to get like a glimpse of what it is we do, please feel free to grab some of those. But yeah, so today we are really excited to welcome two alum from the school and who were also members of the Record in the past. So first we're going to have Pete Davis. He is a member of the Harvard Law School class of 2018. While he was here at HLS, he published a report called Our Bicentennial Crisis, a call to action for Harvard Law School's public interest mission. Looks like this. The report, which is available on Amazon, Apple Books, and HLSreport.org. In it, he outlines the source of Harvard Law's civic deficit and proposes what Harvard Law School in the 3rd century should do to rectify it. Ralph Nader is a consumer advocate, citizen activist, and a member of the Harvard Law School class of 1958. In the 1960s, he repopularized the term public interest law. He has been named by The Atlantic as one of the 100 most influential figures in American history, and by both Time and Life magazine as one of the 100 most influential Americans in the 20th century. So if you could please join me in welcoming both Pete Davis and Ralph Nader.
Before I begin, we have a sign-up sheet to join the Record and get updates from Ralph here, so feel free to sign up. I know you're all here to see Ralph, so I'm going to be brief. I'd say it's great to be back, but mostly it's weird to be back. But I'm glad to be here nonetheless. Ralph wanted me to open for him here today because about 2 years ago, as Diego mentioned, I wrote this report, Our Bicentennial Crisis, that speaks to many of the themes Ralph is going to talk about today. The report came out of a tension I was feeling during my time at HLS. I bet it's a tension many of you probably feel too. As we were leading up to the bicentennial, everyone was talking about how amazing HLS was. We have Supreme Court justices that went to HLS. Senators are coming back. Famous alumni are here to celebrate us. Look at all we've done over the last 200 years. Look how brilliant everyone is here at Harvard Law School. But at the same time as the administration was ramping up the celebration, public interest law students were sounding the alarm of a school overtaken by corporate interests and losing relevance to the average American, of a watchdog of the law largely asleep as the institutions of the rule of law and equal justice under law were under siege, and of a law school community that had lost track of its declared mission to, and this is HLS's official mission, they don't tell you this, but it's their official mission statement, educate leaders who contribute to the advancement of justice and the well-being of society. And while I was here, I didn't buy the administration's response to these critiques and this tension. When I was a 1L, I literally went up to the dean at the time and said, I have all these concerns, and she patted me on the head proverbially and said, you'll understand why everything is the way it is when you're a 3L. But when I got to be a 3L, that didn't come to pass. And so instead of getting jaded, I tried to articulate really what was the problem and what we could do about it in this report. So you can read about my findings in this report, but I'm going to summarize them briefly here today. But before I do, I'm going to begin with a story to show why this is important. Does anyone here know about the Orpheum in Boston, the building, the Orpheum? It's this music venue. It used to be the Boston Music Hall. And if there's one event in American history that I think every Harvard Law student should know about, it's what took place at the Boston Music Hall on December 31st, 1862. At midnight that night, the Emancipation Proclamation was to take effect. This was a big deal. It was the culmination of decades of work by members of the abolitionist movement, and hundreds of them were celebrating in Boston Music Hall that night for when the clock hit midnight, and their work had culminated. On the stage in the Boston Music Hall that night, William Lloyd Garrison, the tireless abolitionist newspaperman, wept next to Frederick Douglass, the famous author and orator who himself had escaped from slavery 24 years prior. Next to them was the armed liberator and Union spy, Harriet Tubman. Up on the balcony was Harriet Beecher Stowe. She was a shy writer. She wrote Uncle Tom's Cabin. She didn't want to be on stage, but they insisted she stand up and get applause. And then it hit midnight, and at that moment, the Emancipation Proclamation was in effect. The law now said slavery was over in the United States, for much of the United States. And the hall erupted in cheers. And the Reverend Charles Bennett Ray, who was an Underground Railroad promoter and the editor of the Colored American newspaper, began to sing a hymn that the whole crowd joined in that night. Sound the loud timbrel o'er Egypt dark sea. Jehovah hath triumphed, his people are free. Their decades of work had paid off. They had won a victory for humanity. I want to tell this story because the biggest message you get at Harvard Law School is that it is what it is, that nothing ever changes and there's nothing you can do about it. What happened in the Boston Music Hall that night shows that when you commit to a cause, when you push at it over the course of a long time, when you give your varied talents to it, writers, speakers, organizers, thinkers, fighters, yes, lawyers, when you don't give up, when you work together, you win. Now, I wrote this book because I think Harvard Law should do a better job of helping attach us to today's respective causes, to prepare us for good work that could together earn similar celebrations of long-awaited triumph in the future. At the very least, Harvard Law should introduce us to the crises in the law, and we have a lot of crises in the law. Learned Hand, class of 1896, said, if we are to keep our democracy, there must be one commandment: thou shalt not ration justice. Are we rationing justice in the criminal legal system? Real indigent spending on defense has fallen while felony cases have risen. 95% of cases are settled through plea bargains. Most people experience their criminal defense as meet 'em, greet 'em, and plead 'em. In the civil justice system, 4/5 of civil legal needs go unmet. Local legal aid offices say 2/3 of the people that show up at their door are being turned away. That's mothers evicted from their homes, domestic violence victims not getting restraining orders, elder abuse going unchecked, veterans not receiving their benefits. And while this is happening, England's outspending us 13-1. Canada, 6-1. The top 100 most profitable law firms, corporate interest law firms, are making $28 billion in profits while only $1 to $2 billion worth of legal time is spent annually on civil legal aid for the poor. And in political life, we are rationing democracy. Public interest lobbyists are outnumbered by corporate interest lobbyists 34-1. Corporate interest foundations are putting tens of millions of dollars into the legal academy, $18 million by the Olin Foundation here in Harvard Law School to teach corporate interest constitutional law. They don't call it that, but that's what it is. And yet in this time of crisis, Harvard Law is failing as a community to wake up to the seriousness of the time. For every one student who goes forth out of Harvard Law School to work in organizations dedicated to advancing the legal interests of the bottom 90% of the income bracket, for every one, 5 students go forth from Harvard Law School to work in organizations primarily dedicated to advancing the legal interests of the wealthy and powerful. This is because the thrust of Harvard Law School is in this corporate direction. We have a culture that fails to spark public spiritedness, that cares more about a cult of smart than a cult of civic smarts. We have a curriculum that pacifies students by taking students out of time. What do I mean by out of time? There's no past at Harvard Law School because there's nothing spent teaching about the history of the law. Too much time spent saying, why must the law be this way, and too little time asking, why did the law end up this way? At Harvard Law School, there's no future. There's no future potential for the law, how things could be, what are the ways the law could be transformed. And at Harvard Law School, there's no present in the law. What is the reality of our legal system, our prison system, our administrative agencies, the corporate firms and what they do? The school treats corporate interest work in the career system, too, as the default option, a process that culminates in an early interview program that streamlines corporate interest recruitment. When I was here, we had a mandatory field trip to a corporate interest firm in the middle of my 1L year. The school career office offered materials that encouraged you to participate in the revolving door. It said, I highly recommend you join a firm, leave it for a government agency that regulates that firm, and then rejoin the firm with a higher paycheck. That was treated as neutral career advice out of Harvard Law School. Now, what does this mean about Harvard Law's relevance to our country? If you're a person in an overcrowded legal aid office, and you learn 80% of the students receiving the best education in the country spend their time advancing the interests of the wealthy and powerful, what would you think? If you're a person pleading guilty to a crime you did not commit after a 15-minute meeting with your public defender, scared of the mandatory minimums, and you learn hardly any Harvard Law student goes into work in public defense after school, what would you think? Does it matter to a refugee that we produce Supreme Court justices if more of us will spend our time filling out paperwork to help the powerful move money across borders than we'll spend our time filling out paperwork to help the most vulnerable people at our borders? If you're a Midwestern governor looking for someone to staff an important state agency, do you care about Harvard's placement rates at New York corporate interest firms? Seen through the eyes of the ordinary America, we risk irrelevance. Now, when I raise these critiques, there's a lot of excuses that the community throws up in defense. I call them work avoidance mechanisms. But what I tried to do in the book here is systematically examine each of these excuses. And when I did, I found that almost all of them didn't hold water. So there's the pro bono excuse. You're going to hear this all the time. We're going to solve this all through pro bono. But lawyers at major corporate interest firms give less than 8 minutes per day to pro bono. Only 18 of the 100 biggest firms meet the very, very minimal requirement of 50 pro bono hours per year per attorney. And when you go, I went to a pro bono, learn about pro bono campus event, and I asked them, oh, at your firm where you're talking about all this pro bono, could I use my pro bono hours to help Walmart workers organize? One of the most important causes of our time, help big box store, retail stores create labor power. They said, oh no, Walmart's one of our clients. We like you doing the safer, less controversial pro bono work. Second is charitable giving. They'll say, you'll raise all this money and then give it away. But the most charitable firms give less than 0.2% of their revenue. Total revenue for the top 200 firms is $96.3 billion. Total funding for all of civil legal aid is $1 to $2 billion, depending on the year. Total donations by all lawyers to civil legal aid is $95.8 million. Million and billion are very different. Then there's the everybody deserves a lawyer idea. Why are you saying these people don't deserve lawyers? I'm fine with that. This is one of the excuses I agree with. Everyone does deserve a lawyer, but let's look at that for a bit. Take the demographics. No one sits with this for a while. The reality is that a disproportionate number of corporate interest firm clients are white and male, while a disproportionate number of public interest clients, government, legal services, education, and nonprofit clients and constituencies are women of color. And that's not mentioning geography. Almost 70% of recent Harvard Law graduates work in just 4 states: New York, DC, Massachusetts, and California. More graduates work in New York than the other 47 states combined. So we pride ourselves, rightfully so, in our diversity of input. Students from every type across all around the country come to Harvard Law to learn. But then when they leave, a vast majority of them, and definitely a disproportionate number of them, go to New York to serve a proportionately rich, white, and male client base. Some say students do public interest work later, but the studies show that only 7.2% of Harvard Law graduates who are working at large firms 3 years out are working in the public interest 12 years out. So if your 1L class has 550 or so people, About 400 of them at the start of their time at Harvard Law want to work in public interest. About 100 of them will in the end. And of the 300 that immediately went into firm work afterwards, only about 15 will have switched over to public interest 10 years later. Another excuse is this is beyond Harvard's control, but CUNY's blowing us out of the water, Northeastern's blowing us out of the water, Georgetown is blowing us out of the water, Yale, not blowing us out of the water, but they're beating us. Some say, okay, stop it, whatever, we serve corporate interests, but at least we're a path to the upper class for America. And for some people, that is true. Harvard Law is the American dream. But the data shows that the majority of students at Harvard Law School are for families from the top of the income bracket. 77.5% of Harvard Law students are from families that make more than $95,000 a year and have more than $175,000 in net worth. So what does this mean? It means if you come from a family with double the median net worth of the average American family, you will still be in the bottom quarter of the Harvard Law School income bracket. The final one they throw up after that's done is they say, why is this Harvard's problem? Well, we have a mission statement to educate leaders to contribute to the advancement of justice and the well-being of society. And we have a mission statement as lawyers, which is Canon 8 of the ABA Model Code, which it tells us that we're not just lawyers, we're officers of the court, and it's our job to improve the legal system. And then finally that gets knocked down, and then there's the worst excuse, and this is how I'll end. The worst excuse at the end is they tell you there's nothing you can do. It's not worth fighting. Now, I want to end with an extension of the story I told at the beginning about this excuse. So, Boston Music Hall, 1862. One person I didn't mention who was up on stage with all of them was a man named Wendell Phillips. Wendell Phillips was from the Harvard Law School class of 1834. He was born and raised a Harvard man. He grew up on Beacon Street, perfect manners, well-connected. He had that Harvard style of impersonal friendliness where you're like, hey, how's it going? But then you don't get vulnerable. He went to Boston Latin School. He was 7th in his class at Harvard College. He went to Harvard Law School. Perfect there. He starts a fancy law practice in corporate interest law on Court Street right after school. And then 1 year out from graduating, he saw a mob in Boston of 5,000 people invade his wife's meeting. It was an anti-slavery meeting. And find William Lloyd Garrison in there, the abolitionist newspaper man, rough him up and drag him through the streets. And what shocked Phillips the most was that he looked at that mob in Boston, fighting against abolitionists, and he saw that they were fellow, quote, gentlemen of property and standing. They were his fellow classmates at Harvard Law School that were dragging that abolitionist through the streets. And so his curiosity was shocked awake, and he reached out to the recovering Garrison after he got better, and Garrison converted him, and there was no going back. So he quit his law practice. He started traveling around the country speaking. He used his Harvard Law skills of having really sharp logic and this kind of affable rhetoric that he mixed with militant content that snuck it through. So it would be this friendly kind of chipper guy up there saying, the spirit of freedom and the spirit of slavery are contending for the mastery of the nation. They cannot live together, and sneak that through. And he didn't stop for the rest of his life. He joined anti-slavery societies. He helped fugitive slaves. He helped the newspaper. When the 14th Amendment was passed, he decried it, saying you need a 15th Amendment for voting, suffrage. And then when the 15th Amendment was passed, he decried it, saying you need to redistribute property to the freed enslaved workers. He said suffrage is nothing but a name because the voter has not an acre from which he could retire from the persecution of landlords. He became known as abolition's golden trumpet. He then fought for women's rights when he was done fighting for abolition. He fought for Native American rights. The whole time he ruffled feathers. He called Daniel Webster, and Daniel Webster was like insulting a Kennedy in Boston at the back of the day, back in Massachusetts, a great mass of dough. He called Abraham Lincoln a huckster for not being hardcore enough on slavery. He said Harvard was controlled by businessmen and dishonest and smarmy about its commitment to abolition. They brought brass bands to play when he gave speeches to drown him out. When he died, One elderly Beacon Hill resident, his own neighbor, said he would not be attending Phillips' funeral, but he wanted everyone to know that he approved of it. But because of this work, Phillips got to celebrate on the stage that night in 1862. He got to win a victory for humanity. He got to be eulogized as, quote, the man who as a private citizen has exercised a greater influence upon the destinies of this country than any public man of his age. A proper statement that is also befitting another man in this room today. Probably wouldn't have expected this out of a Harvard Law School class of 1834 man. We must not get jaded. We must be willing to be surprised by this place. The same place that Upton Sinclair said was a study in class ignorance, class fear, and class repression, at the same time produced Reginald Heber Smith, who fought for legal aid for the poor. The same Harvard Law School that during the Civil Rights Movement had this record dispatch. For the most part, 3Ls who have jobs in southern cities will be doing corporate tax and business work. Although a significant number expressed interest in criminal and civil rights cases, none said they would seek them, particularly in the first few years of practice. One 3L from the Deep South said he would consider civil rights work if there was any hope of doing any good. It takes a lot of guts and idealism to go and work without a chance of success. That was at the beginning of 1964. But it's also the Harvard Law School of Elizabeth Holtzman, who at that time when her fellow students were saying that, spearheaded a civil rights research council here, went down to Albany during her summers, spent her whole time here advocating for civil rights. There's the Harvard Law of the 2000s, where two famous professors sitting in their antiseptic offices waxed poetic about the necessity of the death penalty. And at the same time, Gina Clayton was there, who eventually went on to start the SE Justice Group to harness the collective power of women with incarcerated loved ones. There's a Harvard Law I talk about in this book and talked about here today, and Ralph will talk about, but there's also the Harvard Law that produced the creators of the People's Parity Project, fighting forced arbitration across the country. We have a choice of what version of Harvard Law we want to embody in our time here. Dorothy Day once said, the biggest mistake sometimes is to play things very safe in life and end up being a moral failure. Many of us came to law school because we have a part of us that plays it safe. We have a part of us that is risk-averse about our individual careers. But with crises like the ones we face today, there are bigger risks to consider. Let's get to work. Thank you.
Thank you, Pete. Well, you got a sense of what a real leader is like, and Pete is going to be a great leader in the advancement of justice in our world. And notice how well read he is. He doesn't spend much of his time looking at his iPhone. And so I want to try to compress 5 hours into a few minutes. And this happens every time I come up here. They say you can't speak in the evening because students won't turn out. You have to speak at lunch. You have to provide them with pizza and hope that after the pizza is done, they don't leave. Well, about 6 years ago, we were in the Austin Hall building, and we had about 10 of the greatest fighters for justice in modern American legal history, including former Attorney General Ramsey Clark, the great doer and thinker Edgar Kahn, and this wonderful courtroom, and 70 people showed up. About 25 of them from the community, and the rest were law students. I was introducing Edgar Kahn, who with his wife Jean Kahn graduated from Yale Law School around 1964, having written an article in the Yale Law Journal to establish legal services for the poor. And they went to Washington, and they actually got it lobbied through Congress, and we have 4,500 lawyers servicing the poor as a result of their work. And he went on to start a very practical law school with his wife Jean, co-deans, and he's written all kinds of things. He's a great innovative thinker. He launched the time dollar program. He's written a book called No More Throwaway People, and I'm in the middle of introducing him, and they all finished their pizza, and they started walking out. This is about 6 years ago. What's happening to the culture of this law school? I called Harvard Law School a high-priced trade school, a gross understatement. This is a law school of huge talent. You have experts in almost every field of the law. Some of them are activists, most prominently, of course, Elizabeth Warren now, but others are activists in areas of corporate governance and tort law and rights of shareholders and pension law and civil liberties and civil rights. And they're like Lone Rangers. They are not getting together into a force. There are over 200 law schools in this country. We're in a major constitutional crisis, the likes of which this country has never seen. You wait and see. It's coming on fast, day by day, with Trump and the hesitant activities in the House of Representatives to deal with the most impeachable president of all time. There are at least 12 major areas of impeachability for Trump. And he's in the process of extending the executive concentration of power that has been underway for 50 years in both parties into executive tyranny. He is basically breaking up the separation of powers, and he's appropriating money not authorized by Congress, and he's engaging in wars that aren't declared, and on and on. So the question is, what's the rumble here at the law school? What kind of urgency is there? If you ask people at the law school, is this the best law school in the country? They will say yes. And they have the best and brightest of professors. If you don't believe it, just ask them. The pedagogy is very smug. And I want to show you what happens when you don't have a frame of reference, which you do not have. You're fact deprived as young law students. You don't have a clue of what's going on in terms of the corporate state because you don't study it. You don't read about it. You read about the law as it is, and you interpret it, and you tweak it, and your horizons are very low, and your expectations are abysmally below what they should be, given your status as a top 1% of people your age in the world in terms of your education, your health, and your access to the corridors of power. And when I was your age, I came to this law school, I couldn't believe what I saw. I was totally stunned by the fantasy, the bigotry, the commercialization of the law. If the law means anything, it means justice. There may be many circuitous routes, many technical routes, but if it means anything, it means the disciplining of raw power, the channeling of raw power, the displacement of raw power. The diverse nature of the law has to have a wide embrace. So I arrive here at 1L. First thing I see is there's 15 women out of 550. Women were prohibited from coming to the law school until 1950. The ostensible reason was they get married, they have babies, and they're taking up valuable space at the Harvard Law School. This wasn't even a controversy. Where today you will go nuts over some word or phrase or politically incorrect expression, they didn't even stir at the fact that half of the human race was almost entirely excluded from the practice of law, and the education was a prerequisite for the license. Next thing I looked, there were maybe 2 African Americans. They were called Negroes. I didn't see a Hispanic. Usually the Hispanics were children, sons of Latin American oligarchs and dictators in those days, went to the Ivy League schools. And then I started walking around at night, and one night, about midnight, I was walking past Harkness Commons, and the pages of a casebook were all on the ground. This was early, about now. And I looked up, and all the lights were out. They were asleep, except there was a light on the top floor. So I picked up some of the sheets, and it was the case of Hadley versus Baxendale. Now watch this. You know what my first reaction was? Was it that here's a young man, he may be slashing his wrists. Why did he tear the pages out of his contracts book by Lon Fuller? That wasn't what my concern was. My concern was, gee, why did he pick Hadley versus Baxendale? That's an important case to rip out of the contracts. Imagine that. That was a mind-revealing moment for me in terms of how micro and how trivial the culture can be if it gets to you. Here's what else I learned. There were jokes that were given to us so we could be acculturated in the Harvard law tradition. One of the jokes was, well, at Harvard, in the morning we distort the law of contracts, and in the afternoon we contract the law of torts. Little did we know that's exactly what's happened in the last 50 years. The two pillars of private law, where we do not have to ask permission to use. We don't have to ask a regulatory agency. We don't have to ask the legislature. We can go to a contingent fee lawyer and have our day in court, trial by jury, or we can negotiate a contract or refuse to sign it, are being destroyed. Contracts is now being used to cannibalize torts with compulsory arbitration, with unilateral modification, with waiver of liability, with waiver of trial by jury. We're talking tens of millions of people every day who click on or sign on the dotted line. Is that a crisis at the law school? Is that a sense of urgency that the great freedom of contract that we inherited from medieval England, the law of torts that we inherited from medieval England, are being destroyed and they're in the advanced stage of destruction? Well, look at, maybe it's different now. When I was at the law school, we spent maybe one day on standard form contracts. 99% of all contracts we'll ever engage are standard form contracts. One day. The rest was negotiated contracts, business to business, business to suppliers, business to labor, business to government. Why the distortion? Because that's where the money was. That's where the legal practice were. That's where the clients were. In tort, it was largely driver-to-driver combat and, traumas, et cetera. We never got to the manufacturers of motor vehicles or the designers of highways when we dealt with motor vehicle involved torts. Until we reached McPherson versus Buick. Thank goodness for Judge Cardozo. A wheel fell off the Buick, and we finally got into the product liability sometime in April. It was a year course. We had a course on landlord and tenant. We almost never got to the tenant. Harvard Law grads weren't designed to represent tenants, they represented landlords, developers. And we never thought anything of it. I found my solace at the Harvard Law Record. The Harvard Law Record, the oldest legal newspaper on law school campuses in the country, started in 1946. Not the Harvard Law Review, it was the Harvard Law Record, because that's where the great issues were discussed. The law writ large, not the law writ small. That's where we could pay attention to what was being denied right here on campus. That's where we discussed issues that are now taken for granted in terms of racial, gender, in terms of the corporatization of the curriculum. It continues. I'm emphasizing this because what is it today that you are not sensitive to? We weren't sensitive to all these other things. There was a cover story on U.S. News and World Report. And it said, Negroes are intellectually inferior, says prominent psychologist. McGurk, his name was. And I dropped all my courses and tried to get an anthropologist to rebut it. And I found Ashley Montague at Rutgers, and he rebutted it in a huge article in the Harvard Law Record. Walking through Harkness to Langdell, students would say, what the hell is all this about? When I did one on Native Americans after going through reservations in my summer after graduation Princeton, I did a big cut on Native Americans called American Indians, People Without a Future. My classmates would come up and say, what are you wasting your time on this for? That's not going to get you a good job. I couldn't believe my ears. I went to see one of the deans, and the dean didn't like one of our editorials called Rat Race at Harvard Law School, because it went out to all the alumni, 10,000 alumni. And he said, why did your colleague write this editorial? We tried to explain to the dean that there were major issues of justice, major urgencies that were not even discussed at the law school. It was a commercial curriculum. It reflected the lucrative job markets. By the way, the top pay that year was $7,500, even adjusted for inflation. That must astonish you. But the tuition was $1,000. There wasn't any problem of student debt. Well, let me just imprint this a little bit. I want to give you 3 quick stories and see if I can penetrate the culture that's closing in on you. It's a culture of technical rigor embedded in a broader framework of civic rigor mortis. That's what's happening to you. How do I know? Because Robert Meharry, who's the editor-in-chief of the Harvard Law Record, put the Harvard Law Record on every table, every desk for 1L. How many of you remember that? How many of you have read it? He put an invitation for any of you to call me or to email me to discuss 4 articles that are in this that I had written. One is an open letter to Harvard Law students. One is a plea that Harvard split its curriculum between Harvard Law School and the Harvard Lawless curriculum school and explained it. The third was, so you want to go to work for a corporate law firm? And I gave all kinds of examples how your forebears defended the tobacco industry and its cancerous impact, how they tried to enhance government secrecy, how they fought every major social justice movement of the last 50, 60 years, the environmental movement, the consumer movement, the labor movement, how they even fought equal opportunity for women and minorities. They were the brains, they were the architects, how they stripped the owners of corporate capitalism from any control over what they owned, otherwise known as shareholders, pension funds, mutual funds, individuals, how they greased the way for streams of corporate criminality. And if it wasn't criminality, it was criminogenic, because the corporate lawyers got up to Capitol Hill and cut out of the health and safety regulatory agencies the criminal penalty for a willful and knowing violation that led to death, injury, disease, and property damage. And then the fourth one dealt with another subject that's close at mind. And I urge you to read them. I didn't get one call. There's no voicemail on that phone number. I didn't get one letter. I didn't get one email. So let me start with this very briefly. Isaac Newton once was at a party, you know, the 17th century physicist. A person came up to him and said, Mr. Newton, why are you so much more brilliant than your fellow scientists? He looked at the person and he said, I'm not much more brilliant than my fellow scientists. I just can hold the problem in my head and perhaps concentrate on it longer than most people. Concentration, pull that out. The second was the artist and the poet, William Blake, 17th, 18th century. And he was at a gathering, and someone came up to him and said, "Mr. Blake, with whom are you living these days?" And he said, "With whom am I living? I'm living with my imagination." Cut that out, imagination. And then Einstein, rather modestly, was heard to say once, "Well, I have no special gifts. I just have a passionate curiosity." Curiosity. I don't think you have to worry at Harvard Law School about concentration. I think you have to worry a lot about curiosity and imagination. The curiosity that makes you attend lectures at the law school that aren't any good for the bar exam, like jurisprudence and legal history. The curiosity that has you go over to MIT and Harvard departments and take in lectures and events of anthropology and statistics and sociology and history and the connection between technology and law, which is Robert Meharry's going to put on a big event for you. It's the curiosity where you show up to extracurricular events that have so many empty seats here at Harvard Law School. So many empty seats because you're too busy. It's the curiosity that has you pick up books that have nothing to do with West Publishing. By the way, the West Publishing case books that we had in the 50s on property and contract didn't have one case involving slaves. You want to talk about censorship? And I was told once that's because West Publishing wanted to sell us books in the Southern law schools. Not one case that was a huge major source of litigation in the antebellum period. We didn't even see it. I didn't even see it. I didn't even notice it. Imagination is even more important. Einstein once said it's more important than knowledge. How could he say that? Because it's a precursor to expanding knowledge. Imagination is asking, what are you going to do with your lives in the next 16,000 days, which is about the length of your career, if you're lucky. It's asking, how can the rule of law control the rampant epidemic of multiple forms of raw and cruel power? In 2002, in Wired magazine, Bill Joy wrote the article, "The Future Doesn't Need Us." I'm sure, Bill, you read that one. One of my co-authors is here, Bill Taylor. I have so many friends here who came up. What did he mean by the future doesn't need us? He meant 3 technologies that have no legal and ethical framework. Just imagine. Imagine 3 technologies more perturbing on this planet than nanotech, biotech, and artificial intelligence. No legal and no ethical framework. Full speed ahead. I'm sure there are courses here dealing with this. I'm sure there are hypotheses. The question is, where's the action? There's a Chinese proverb, 14th century Ming Dynasty. Has a lot of truth to it. To know and not to do is not to know. To know and not to do is not to know. We expect leadership from our law schools. We expect leadership from our law students. We need you. We're not flattering you. We're not interested in inspiring you. That's a way to patronize you. We're interested in you in coming to grips with what you are going to face as a trustee for the rule of law all over the world that's being driven and blasted into smithereens. What's left of international law with countries blowing apart other countries led by the USA and the military-industrial complex that Eisenhower warned about us so presciently? What's left of the congressional authority exclusive to declare war? What's left of the congressional authority exclusive to authorize and appropriate funds? The whole constitutional legal structure is being destroyed more and more. It's always been violated. Lawlessness is the norm when it comes to the rich and powerful. It is not the aberration, which is why when you come to this law school, you should have a choice. You want to be a traditional lawyer, draft contracts, deeds, represent corporations, or do you want to focus on lawlessness, which is the norm? For example, right near here is the world's expert on billing, fraud, and abuse in the healthcare industry. He's at the Kennedy Institute, or department, whatever it's called, the Kennedy School. His name is Malcolm Sparrow. He's an applied mathematician from England. He wrote the book License to Steal. What does he mean? He means that the design of the billing practices that are fed to Medicare, Medicaid, and the health insurance industry are rife with fraud. They're rife with ghost surgeries, items never delivered, manipulation of Medicare codes. Here's his most conservative estimate: $350 billion a year. That's about $1 billion a day. No politician is running against it. No politician mentions it. Just imagine, are there certain crimes that are okay because they come from high places? 350 billion. He thinks it could be 700 billion. It's not like we have great statistics here. 3.5 trillion is spent on health care. 10%, a GAO report in 1992, 350 billion. That's a lot of lawlessness, isn't it? That's a lot of contracts being violated, isn't it? That's a lot of larceny, isn't it? Where's the rule of law here? It's lawlessness is the norm. 5,000 people a week, according to Johns Hopkins School of Medicine, die every week from preventable problems in hospitals. Every week. That's far more than 9/11. Oh, but you say it's not intentional. The issue's preventability, isn't it? Is it consoling to a mother who lost her daughter to malpractice or to hospital-induced disease? To say, well, it wasn't really deliberate, it was just negligent? Some of it is criminal in terms of cutting corners deliberately. Now, did you know that? Did you know those two sets of reliable estimates? If you don't know that, that's what I mean by you're fact deprived. It's not your fault, perhaps. You have such innocence. How many people are 1L? How many people are 2L? Now, how many people are 3L? See what I mean? See what happens to you? You come in idealistic, and you get processed. It happens all over the country. The 1Ls are the majority. Then there's far less 2Ls. Then there's 3Ls can't be bothered. They can't be bothered. Let me give you a little insight. There's no graduate school at Harvard University that is easier to get through than Harvard Law School. Hands down. If you don't care about getting A's, you can have the best education and avoid being technically narrowed and not worry at all about exams and bar exams. Bar exams, by the way, are eminently crammable in more than one way. You don't have to worry. take the bar exam. I've often said, give me a high school student with a high school degree, and within 6 to 8 months, I can have that high school student pass the bar exam, never having gone to law school. So relax. Don't take Valium or other things. Don't be worried. If what you want to be is a fighter for justice, if what you want to be is stand in the shoes of a few Harvard Law graduates who blazed their way in civil rights, civil liberties, environment, labor, consumer, a small number of them, you don't have to be terrified with these exams and classes that are run by professors using the Socratic method, a game only one can play, right? If they still use it. So let me give you a little more advice. You will be the first generation of law students who will not be able to escape, no matter how rich you become. The universal assaults of runaway technology, of climate disruption, of mutations of viruses and bacterium, of decentralized weapons of mass destruction is upon us. You will not be able to escape by living in Belmont or Scarsdale or Beverly Hills, like your predecessors. I'm calling for a deep sense of urgency among law students. Your predecessors are responsible for 32 clinics. There was one clinic when I was a law student, and it was debated as to whether it should exist. Your predecessor students diversified the faculty. You had some assistance by some few professors, but it was demands by students. Students in those days demanded changes in behavior, in action, in deed. They weren't quite as upset with words and phrases like your generation is. They wanted real changes. What framework you're lacking is the corporate state. Corporations have been strategically planning every area of our life. There is no such thing as a commercial-free zone anymore. They're strategically planning our elections, our government processes, our court nominations, our food supply. They're planning our land use. They're strategically planning our environment, fossil fuels. They're strategically planning our genetic inheritance, thousands of gene sequences patented. They're strategically planning almost everything you can imagine, including our childhood, the commercialization of childhood, directly promoting, damaging goods and services, selling violence, interactive violence, junk food, junk drink, obesity epidemic, diabetes at a young age, high blood pressure coming on. These are processed food killers, and they're doing it over TV using our airwaves. These are electronic child molesters, directly marketing to children, bypassing the authority and discipline of their parents. This is not a left-right divide issue, is it? You have now a food center, food and law. Bravo, it's good. When I was walking out of a class one day, I asked my professor, why isn't there a seminar on food and the law? Why aren't there courses on food and the law? He looked at me and he said, food? And I was sort of in awe. And I mumbled something like, yeah, you know what we eat. And then he stroked his jaw. I don't think there's one woman professor You should read this article on Professor Steicher in Harvard Law Record, page 1. He stroked his thought, and he looked up, and he said, it's quite possible that food law has not sufficiently developed to a level of complexity that would afford a sufficient intellectual challenge to our students. I'll let you fill the rest of the blanks. So then I asked him, but Professor, what do you think does? What subject does? And he looked at me, and a gleam of delight came over him. And he said, why, tax law. I was once having lunch with the IRS director, the director of IRS, and I said, is it true? Someone once said that there are more people who understand Einstein's theory of relativity than the insurance code in the IRS. And he said, I wouldn't doubt that. And I said, well, how can you possibly enforce it? He said, that's a very good question. We can't. The complexity itself prevented the IRS from enforcing it. It didn't have the resources, didn't have the actuaries. Okay, so let me just run this quickly through. For those of you who are interested, I'm going to be at the Animal Law and Policy Group at 4 o'clock. I think anybody is invited, 4:30. And that is an extremely important subject now. It's not just the prevention of cruelty to animals. As Barry Commoner, the great ecologist, said, the first law of ecology is everything is connected with everything else. So one thing you might want to ask your courses, are these courses empirically starved? Is my contracts course? Is my property course? Does my property course go into the commons? The greatest wealth of our country is not owned by the rich. It's owned by we the people, the public lands, the public airwaves, the trillions of dollars of R&D that built Silicon Valley, that helped build the aerospace industry, the drug industry, the nanotech industry almost entirely, the biotech industry, not to mention the computer internet industry. Does our property go into cooperative forms of ownership or just stock forms of ownership? Does our tort law talk about the destruction of tort deform? Or is it a Chicago School of Economics fantasy of maximizing consumer welfare? The destruction of the law of wrongful injury is the destruction of a huge range of protective law for the innocent and the defenseless. It should be built right into the tort law at its core. And what's going on at state legislatures? What's going on in Georgia in January? They're moving to change the common law of torts into a workers' comp system. So much for an arm, so much for a leg. Stagnant, not breathing new values, not evolving. Oh, here's just a few suggestions. When I was at 1L, they brought us all together, and Dean Erwin Griswold said, welcome to Harvard Law School. You are now a member of the legal profession. I turned to my friend, I said, this is amazing. We haven't cracked the book, and he says, we're a member of the legal profession. What did he mean by that? He meant that we were then lawyers. The distinction between lawyers and attorneys, I never had a discussion in any class at the law school. You get licensed to be an attorney and attorney for clients, zealously representing them, okay? But by that same token, you have to have another side to your profession, which is the lawyer, looking out to advance justice, even if you don't get paid for it. It's the kind of work that deals with prison reform, with congestion in the courts, with the starvation of the court budgets, with the criminality of coerced pleas by prosecutors. It's the kind of lawyerly that exposes the lawyers, led by a prominent lawyer in Philadelphia, who goes all around state legislatures and corporations slashing your freedom of contract. He glorifies in it. He gets prestige by it. The #1 contract slaver, the fosterer of contract servitude and peonage. Look at your landlord-tenant contract, for example, to see how one-sided it is. Look at your click-on. You can't even see the contract to decide what you're clicking on. It's a farce. It's a fiction. What are you studying in contract law? Business, negotiated contracts. Do you discuss the difference between charity and justice? Law school likes to say the students are doing good charity, good legal aid. That's important for people who are right on the margins and hurting, right? But justice deals with prevention. It deals with system change. And that's where the law school is lacking. Will it occur to you to look into the Harvard Law School endowment, which is by far the most gigantic endowment of any law school in the country? What are they doing with it? Why should you be paying tuition? They're getting better in that respect, of course. But why doesn't Harvard Law School start all kinds of public interest law institutions around the country? I mean, look at the mission statement that Pete read to you twice. Why don't they do that? They say, well, you're free to become a public interest lawyer. Yeah, good luck. Where are the jobs? There's just a handful of them. Where are the jobs? The demand for justice is massively greater than the ability of our profession to supply it. Where are the jobs? That's what the role of Harvard Law School. About our 30th or so reunion, I spoke to my classmates, class of 58, 35th reunion. I said, what are we doing here? Most of them were corporate lawyers. I had very little in common. But we agreed on one principle, that there wasn't too much justice in America. On that basis, we started the Appleseed Foundation, which has started, in turn, 17 centers for law and justice in 17 states. Some of them are small, to be sure. But that's just one law school class that did that. Just one law school class. Texas, District of Columbia, other states. What if all law school classes did that? Yale, Harvard, Bolt Hall, Stanford, BU, Boston College. We would have a vast expansion of opportunity for you. You wouldn't just be exhorted to be idealistic and do a little pro bono work in Cravath Swain or Covington and Burling or the other corporate law firms. You'd be able to take your conscience to work from the get-go. Why don't we hold Harvard Law School up to higher standards of expectation? Do you know that there's a database here at the law school that reports voluntarily the consultantships of your professors? Who are they moonlighting for? Some of the professors think it's a violation of their civil liberties to file their clients. Others file their clients. Most law students don't know about it. Do you want to be taught antitrust by day and your professors representing conglomerate mergers by night? You have a right to know. Why don't you have a gathering in February, which is a dead month at the law school, and talk about expectations for the Harvard Law School? When I was a 1L, we went to Austin Hall and we were visited by the president of the University of Chicago, Robert Hutchins, who was a dean of Yale Law School at age 29, a wonder king. And I'll never forget the question he asked, and we all laughed at him. He said, what is the purpose of the Harvard Law School? And we just laughed. Harvard Law School have a purpose? Professors have purposes. Law students have purposes. How can this institution have a purpose? It's just an enabler of us. I think that needs rethinking. This is really important. When you're a lawyer licensed, you are not just a private individual. You're a quasi-official person. You're an officer of the court. Ask your professors, What does that entail in terms of responsibility, being an officer of the court? Other than obeying the criminal laws, there's almost nothing that it entails. And it should entail a lot because you've got a monopoly operating here. You've got a cartel. And with that power and privilege comes some responsibilities. Think it through. What should the officer of the court have a responsibility for? Access to justice, greater support for indigents. You have public defenders who've been working for 6 years in Florida. They're making $45,000. We're starving legal aid. We're starving public defender. You think Abu Ghraib was an outlier out there in Afghanistan? Try our prisons. That's where they learned it. Highest percent of incarceration per capita by far in the world. Corporate crime reporter, anybody hear of that? That's in your great library. Write your third year paper or your seminar paper on some aspect of corporate crime. I wrote my third year paper on unsafe auto design and legal liability. Turned it into a book, turned it into a mission, the Motor Vehicle and Highway Safety Laws of 1966, irregularly enforced, averted 3.5 million lives and many more million injuries. Anybody could have done that. I was nothing special, except for one thing. I wasn't going to be a cog in a corporate wheel. I wanted to do something significant to connect law with justice. When my father took me to the local county court house a few blocks from my restaurant, family restaurant in Connecticut, I was 5 years old. And my father never identified lawyers with anything other than justice. Each one of you can be a major leader in one or more struggles for justice, systemically, not just episodically. That's the difference between justice and charity. Here's another one. You are not lawyers in waiting. You can make a huge difference as students. Break open these hospitality suites and the way the corporate law firms come here. Provide surveys of corporate law firms the way the class of 1970, led by Mark Green, did. He surveyed, those students surveyed the corporate law firms. What's your pro bono policy? What's your conflict of interest policy? Do you penalize people who do pro bono instead of working full time? How many hours of billable hours? Anything over 1,500 is larceny of the client for young lawyers. Some young lawyers are pushed to do 2,500, 3,000 hours. That's criminal billing. That's working on the client's time to research yourself. So I would suggest that you get together and you say, how can we connect with other law students all over the country regarding this constitutional crisis, regarding this endless illegal wars, regarding the corporate crime wave? Pick your poison. As I say, we need you desperately, because something you've never thought of, I'm sure, that when it comes to members of the bar in their 30s, 40s, 50s, 60s, 70s, law students are the conscience of the bar. They cannot look you in the eye when you throw in front of them the demand to direct their attention, resources, contacts, and influence on the great injustices of our age. You are their conscience. You are not their supplicants. You're not their beggars. You are their conscience. Remember, you're the first generation of law students that cannot escape what is already over the horizon. And let me end on this. Any of you want to see how to be a community lawyer? We have the first community lawyer in Connecticut. There's a description of it. There are a lot of good materials here that where are they? Yeah, they're all, where?
They'll be on the back table.
They'll be on the back table. We just had the first Tort Law Education Day in American history at the American Museum of Tort Law. You were all invited, tort, not one came. It's only 2 hours away, beautiful Litchfield County on Saturday. You got to venture. You have to be curious. You have to have imagination. Why is this the only law museum in the world? What does that say about our profession? There are 32 timber and lumber museums. There's 16 medical museums. Why only one law museum? Why aren't we bringing the law to the people, which is what museums do now? As Justice Breyer visited this museum and called it an excellent educational institution. Those were his words. So it's wide open for you. It's like fishing off the Grand Banks of Newfoundland in 1802. Pick your injustice while you're a student and latch on to it. Don't get too creepy into the cases, underlining your cases or whatever you do now. Look at the law writ large. Look at your mission. Have a higher estimate of your own significance. The people who are at the top of my class, you look at what happened to them. They're at the top of the class, they got the best jobs and the best firms. 60 years later, look at what happened to them, with one exception. Richard Goodwin, who went on to do very important things. They got caught in the machinery, and they couldn't let go. All right. There's a lot more to say, and we're out of time, unfortunately. As Edgar Kahn would say, we belong to a profession where the vast majority of people can't afford our services. How's that one? We belong to a profession that's a cartel and needs to be deconstructed. So there are many more lawyers, so we get rid of the 4-year undergraduate requirement to go to law school. That's what all other Western European countries do. That will cut a tremendous amount of money and debt from that. A class of 1970, Robert Fellmeth, F-E-L-L-M-E-T-H, he's just written a law review article on the cartel and what to do about the profession. You think there's anybody better, potentially, than law students to ask the impertinent questions? When I was at law school, we were encouraged to challenge everything, even the decisions of Judge Learned Hand. But there's one giant exception. We were never exposed to challenging corporate law firms. The architects of criminogenic and criminal corporate capitalism. The architects of the corporate state, Wall Street controlling Washington. The merger of big business and big government. Isn't that amazing? Do you think that's accidental? Do you have a seminar on corporate law firms? Why not? You have the first seminar by Professor Jennifer Taub on corporate crime. It's such a hideously fearful phrase at Harvard Law School that they call it white-collar crime. They can't call it corporate crime. Corporate crime is corporate crime. White-collar crime is when a bank teller cheats a bank. But what BP, VW, Volkswagen, what Pfizer, what Bank of America, Wells Fargo have done, this is corporate crime. And why isn't there a major at Harvard Law School on corporate crime? Why do your deans hug the chairman of Goldman Sachs and don't show up at the greatest assemblage of justice fighters 6 years ago in Austin Hall to even say hello. These are the kinds of questions you should ask. Who are the overseers here? Who are the governors of Harvard Law School? Dig into the endowment. Do not spend the bulk of your time on your courses. 50% is enough. Otherwise, they're going to twist you into a pretzel, and you'll be nothing but champions of complicity with everything that goes wrong in this country, behind which there is always a corporate lawyer. Show me anything, including what Trump is doing and trying to get away with now. The lawyers are the architects, and they have to be held accountable by public interest lawyers, by more Appleseed centers, by more institutions established by the endowments of the richest law schools in the country. Concentration, curiosity, imagination. Break your routine. If every weekend is like every other weekend, you're in trouble. Break your routine. Go without the cell phone sometimes. The cell phone is the modern metaphor. When Marx said religion is the opiate of the people, the cell phone is now the opiate of the people. It is your incarceration. I give books to law students these days. It's like they've been insulted. A printed book? Do I have to carry this? Readers think, thinkers read. You don't do that, you're not going to become a lawyer struggling against the forces of injustice. It's that simple. The cell phone is the ultimate trap in all kinds of ways. Last point, is Tommy Raskin here? Tommy? Tommy's 1L, he's the son of Jamie Raskin, who was the leading protagonist for the impeachment of Donald J. Trump. His father, Tommy's grandfather, was Mark Raskin, who wrote a book called Being and Doing. Being and Doing. He was an advocate, he was a litigator, he was a lobbyist, Mark Raskin. And one thing he taught his son and his grandson is that there's no bifurcation of the conscience. There's no bifurcation of the intellect. And that a profession, in contrast to a trade, has a tradition of public service, must remain independent, and has a learned tradition as well. That's what you're up against. So the first thing you need to resist is the contemporary culture here. The second is to find the free thinkers in the faculty. And the third is to ask your faculty, what is it that makes a few law professors activists for reform and the majority of them just academics? Have a symposium on that. Everything you've heard this morning is in the Harvard Law Record, the first edition, all 4 of those articles. I hope you read them, and I hope you look back on your years of Harvard Law School as incubators and as agitators for a way of life that you will never regret. You talk to corporate lawyers when they've retired, they have a lot of regrets. They missed the justice bandwagon. I talked to one once who spent 15 years representing Geritol, a drink, before the Federal Trade Commission, claiming that its advertisement that Geritol fixes tired blood was deceptive. He sent his kids through college on that. But imagine some of the best years of his life, he's representing a defense of an ad that connected Geritol with treating tired blood. Those are the words. If you don't think you're going to end up this way, of all the 4 articles that are on the record, hlrecord.org, and also that, read the one that's titled, "So You Want to Go to Work for a Corporate Law Firm," and escape the plausibility of simply saying, well, the worst corporations deserve a lawyer. That's right, they do. But it doesn't have to be you. It doesn't have to be you. They'll always be able to get a lawyer. They'll always be able to get 100 lawyers. But it doesn't have to be you. Thank you.